Also say before we start that we've got copies of Tim's book, The Right to Earn a Living, is available out in the lobby, and he'll be signing copies after tonight. So I'm sure all of you, 100% of you, won't buy a copy of the book, but I hope some of you will buy a copy of the book. So we appreciate you all coming out tonight. Tim Sandefur is a principal attorney at the Pacific Legal Foundation. As the lead attorney in the foundation's Economic Liberty Project, he works to protect businesses against abusive government regulation. He also works to prevent the abuse of eminent domain, having litigated important eminent domain cases in California, Missouri, and elsewhere, and having filled briefs in many significant eminent domain cases across the country. He has been published extensively and has appeared regularly on TV and radio shows. Tim actually appeared at the Dole Institute. He and I weren't sure if it was May of 07 or of 08, so we'll leave that one open-ended when he talked about his previous book on eminent domain. And Tim, we're very glad to have you back. Please welcome Tim Sandefur. Before we go to the book, before we get into the crux of that, talk to us a little bit about how you got interested in the law and a little bit about your background and where you went to school.
Well, I was in college in Michigan at a school called Hillsdale College, and I heard a speech given by a lawyer named Clint Bullock, who came in to speak about a case that he had recently worked on in San Diego, California. And this is a case where his client was doing, she ran a business doing hair braiding for clients, traditional African hair braiding techniques. She wasn't a barber. She didn't cut hair or treat hair or style it or anything. Just did this hair braiding. But the state of California said that was cosmetology, and that in order to do that, she would have to first have a cosmetologist license, which required 2 years of training, learning how to do various kinds of hairstyles that had been out of date for many years, and a whole variety of other skills. The trial court later found that more than 95% of the required curriculum was utterly irrelevant to the trade that she practiced. Nevertheless, if she were to go into business doing hair braiding for her customers, that would be a violation of the law, and she could be charged with a crime for that. Fortunately, that law was challenged as unconstitutional, and she won that case. And when he told this story, I thought that is what I need to do. Because I'd already been thinking about doing law, because I'm attracted to the big philosophical issues of the role of the state and individual rights and things. But in the law, you can apply those principles in real life and put them into practice. And here was an area that I could go into where I could work to protect the rights of America's entrepreneurs, of America's wealth-creating individuals, who are the people I admire most. It's the best part about my job, is getting to meet these amazing people who have the guts to go and start their own business. You know, I would never have the courage to do that, and I'm amazed by people who do that. So I decided there and then that that's what I wanted to do for law, for a career rather, and I went to law school at Chapman University in Orange County, California. And shortly after that, I took a job at the Pacific Legal Foundation, where I run our Economic Liberty Project, defending entrepreneurs against that kind of ridiculous licensing law or laws that prohibit them from lowering their prices and other kinds of restrictions on economic freedom.
Okay. Why did you write this book?
Well, there's very much a need for this book. The right to earn an honest living, the right to earn a living by applying your own skills at a trade to provide for yourself and your family without unreasonable interference from the government is, when you look into the history, a cherished right with more than 4 centuries of common law precedent behind it. The oldest case on the subject I found is from the 14th century, but it really picked up steam in the early 17th century, in Shakespeare's day. Courts started saying that every English subject had a right to earn a living without unreasonable interference by the government. And this was one of the bedrock principles of American constitutional law for a very long time, until about the 1930s. And about that time, courts started ignoring the freedom of economic choice and saying that government could intrude on the freedom to make economic decisions for yourself about what jobs to take, what businesses to start, what wages to earn, what hours to work, and allowed legislatures to take this freedom away from people to an increasing degree. And in all the time that's passed, so far as I know, there's only one other book on the subject, and that's Bernard Seagan's classic 1980 book, Economic Liberties and the Constitution. That's one reason why I dedicate my book to him. because he was really a pioneer in this area of legal research, of recovering these principles that had been forgotten by the law school community.
I want to come back a little bit later to the 30s and some of the court decisions, because I know you write at length about that period of time and some of the things that were done, but I want to cover some basic background first. Talk a little bit about this. Do you feel that political and economic freedom can exist separately, or can they only exist in combination?
I think there might be efforts to have the two things exist separately, but they can't last for very long. A classic way of putting it is that you can't have a free press unless you can own a press. If the government owns all of the press, owns all the machines, then how could you possibly hope to have a free way of expressing yourself in print? And the more restrictions there are on property rights and the freedom of economic choice, the less opportunity there is for political freedom. Now, political freedom is also secured not only by private property rights, but by the opportunity to earn a living for yourself and your family, which is one reason why the authors of the 14th Amendment, when they wrote that amendment, hoped to protect economic liberty for the newly freed slaves, to give them the opportunity to stand on their own 2 feet and not depend on a racist white power structure. Now, unfortunately, their attempt failed, largely because of the U.S. Supreme Court. But it was by allowing people the economic freedom to build up their businesses and things that then people could take the next step of protecting themselves against attempts to deprive them of their political rights. So I think that economic freedom and political freedom are deeply related. At bottom, they're the same right, which is the freedom of choice. It's the freedom to decide for yourself what you want to do in terms of economics. You know, we talk about freedom of religion. What is freedom? Freedom of religion is the right to decide for yourself what faith to follow, what church to go to, and so forth. And it ain't nobody else's business if you do. And when we talk about economic liberty, it's the same thing. It's the right to decide how to run your business, what business to start, or what to charge for your services, or what to earn, how long to work, and it ain't nobody else's business if you do.
So what you're saying, I think, in essence, is that freedom of religion, freedom, political freedom, freedom to spend the money you earn the way that you choose, not the way somebody tells you to, those 3 things are essentially the same. They're all freedom of choice in your view.
Thomas Jefferson once said that freedom, that he defined freedom as the ability to decide for yourself what to do with your ideas and your faculties and your mind, your religious beliefs, your political opinions, within the boundaries of the rights of other people. As long as you respect other people's rights, you have the right to run a business, or if you don't want to run a business, to work for somebody else or whatever, in the same way that you have freedom of religion or freedom of political choice. And a government that's going to deprive you of the opportunity to run your own business has set the precedent for depriving you of other rights of choice.
What are the protections in the Constitution for Americans' right to earn a living?
Well, there are a number of them, but there are 2 that are the most famous. One is the Privileges or Immunities Clause of the 14th Amendment, and the other is the Due Process Clause of the 14th Amendment, which also appears in the 5th Amendment. The Privileges or Immunities Clause, when you look at the history, and I go into this at length, not only in my book, but in a recently published law review article in the New York University Journal of Law and Liberty. When you look at the history of the Privileges or Immunities Clause, it's quite clear that one of the rights, one of the privileges or immunities of citizens of the United States that was protected by that amendment was the right to earn a living for yourself and your family without unreasonable interference from the government. The Due Process Clause was also used because the term due process of law is actually synonymous with an old phrase from the Magna Carta, the Law of the Land Clause. And the Law of the Land Clause was the provision under which those old English cases that I mentioned earlier, that's what those were decided under. As far back as 1602, there was a case called the Case of Monopolies, where it was illegal for anybody to make and sell playing cards without permission from the government. And this guy went and made and sold playing cards and was brought up on charges. It went up to the English version of the Supreme Court. And the court held that monopoly was illegal or unconstitutional under the Magna Carta's Law of the Land Clause. And that began a legal tradition, the Whig anti-monopoly tradition, that prohibited the government from restricting some people's economic opportunities in order to benefit a favored class of insiders. And so those two provisions are the most famous protections for economic liberty in the Constitution.
Well, let's go back now. You mentioned a few minutes ago how that your feeling is that the Constitution was severely challenged by the Supreme Court by a variety of decisions in the 30s. Talk a little bit about that. I think you outline in your book 4 specific ways that the Constitution was challenged.
Yeah, what happened was in 1934, the Supreme Court decided a case called Nebbia versus New York. Now, it has to be made clear, there really are no such things as sudden, dramatic changes in the law. The law changes as a result of gradual change in philosophy, in economics, in morality, changes in social arguments that gradually work their way up to the Supreme Court. So it's not like everybody woke up one day and this was the way things were. What happened in 1934 was the climax of the progressive movement that began in about the 1880s. And this was a group of intellectuals who radically altered how the constitutional structure works in this country. And their 4 big ideas were: rights are just permissions that government gives you. The American founders thought that rights belong to you because you're a human being, and no just government may deprive you of those rights. But the progressives believe that rights are permissions that government gives to you for government's own purposes. So, for instance, Oliver Wendell Holmes wrote a famous opinion called Abrams versus United States, where he said, it's famous today as supposedly a free speech opinion, but the first line in it is, persecution seems perfectly logical to me. He then goes on and says, but we don't persecute people because it's good for society to have a debate, so we allow people to debate things. And then, when we want to, we can shut them down. So he also wrote a case called Schenck versus United States, where he said it was okay to throw somebody in jail for handing out pamphlets protesting against the military draft. And that case is most famous for his line, yelling fire in a crowded theater, because, yeah, handing out pamphlets protesting the draft is just like yelling fire in a crowded theater. Right? Holmes was a great enemy of liberty and certainly one of the worst human beings ever to serve on the Supreme Court. Anyway, the second great progressive idea was government exists to make society nice. Right? The Founding Fathers thought government exists only to protect our rights. That's what they say in the Declaration of Independence. That's what Jefferson said in his first inaugural address. He said, "The sum of good government is one which shall restrain men from injuring one another and leave them otherwise free to regulate their own pursuits." But the progressives believe that government exists to make society fun to live in. Right? So they came up with these radical new programs for how to make society nice. Segregation, eugenics, prohibition, the income tax, the use of eminent domain for redevelopment, and other vast government programs to shape society. The third great progressive idea was judicial restraint, which means that when the government violates your rights, courts should stand back and do nothing about it. I'm sorry to say a lot of my conservative friends believe this idea too. And one of the great examples of judicial restraint in recent years is the Kelo case. Right? In Kelo, the government steals somebody's property and gives it to a private developer, and the court says, we're not going to do anything about it. That's judicial restraint. Right? And then the fourth great progressive idea was the living Constitution. The Constitution changes over time. It doesn't mean today what it meant yesterday, and so forth. And Louis Brandeis, who was a progressive Supreme Court justice, he famously said, property and other rights of the individual must be remolded from time to time to meet the changing needs of society. I love that line because I love the word remolded. A great euphemism for violated, right? Oh no, we're not violating your rights. We're just remolding your rights in the interests of society. Right? Now, if it can be remolded, it's not a right. We would never allow somebody to say, well, we're going to remold your freedom of religion to meet the changing needs of society. Right? But that was the progressive attitude toward economic freedom, private property rights, and so forth. And those ideas boiled along until 1934, when in Nebbia versus New York, the Supreme Court made that into constitutional law by creating what lawyers call the rational basis test. And that's the test that courts still use today. And under that test, any regulation of the economy, any regulation controlling private property rights is held to be constitutional in all but extremely rare circumstances. And that's the law today, thanks to the Nebbia case. So what happened in 1934 was courts backed away and said, we're not going to take seriously the rights of economic freedom of choice, the right of private property, and other rights that previous generations had held sacred. And that's the world we live in today.
Would people who criticize judicial activism say that That was one of the greatest periods of judicial activism, kind of maybe the beginning of it?
You might say that. I think the term judicial activism is meaningless. I think the term judicial activism is something people say when they disagree with the court's decision. And the reason I say that is because I think all of us want courts to be active in enforcing the Constitution. And courts should not at all be active in stepping beyond their constitutional boundaries. But the term activism, it's so imprecise, it doesn't seem to mean anything, right? What is a court's job? A court's job is to say, is this law consistent with the Constitution? Or what does this law mean? Or how do we interpret that statute? Prudential decisions about the political impact of that kind of ruling really don't belong in such an analysis. What a court ought to be doing is saying what the law is, not saying what the political effect of the decision will be and so forth and so on. So I'm not really concerned about what people call judicial activism. I'm concerned about whether courts enforce the Constitution and what it really means. Now, you could say that the 30s were a period of judicial activism in the sense that courts relatively suddenly altered the way the Constitution worked in this country. I mean, within the period of 10 years, from 1930 and 1940, if you had been Rip Van Winkle during that period of time, the legal world looked very different at the end. So you could say it was activist, but the way it was activist was the court said, we're not going to do our job. We're going to stand back and let legislatures and Congress do whatever they want. So in that sense, it was too passive.
Would it be fair for everyone to assume that your view of the Constitution is that it's kind of a static, literal thing as opposed to being a kind of living document?
My view of the Constitution is, as Frederick Douglass said, interpreted as it ought to be interpreted, the Constitution is a glorious liberty document.
Now, what do you mean by that?
I mean that the Constitution has a normative direction to it. It's not morally neutral. The first sentence in the Constitution of the United States says unambiguously that liberty is a blessing. It doesn't say the same thing about government or about democracy or about participation in the voting process or anything like that. What it says is liberty is a blessing. And then it goes on for several pages limiting democracy, restricting democracy through all sorts of procedural rules. One house has to pass something, then another house. Some things need 2/3 votes. President has to veto it or sign it, or he can veto it or whatever. All these limits in order to protect liberty. So you could say that the Constitution is a living document in that the principles of liberty, the principles on which the Constitution is based, live and breathe every day that people believe in them. Obviously, it's not a machine that goes of itself. But as long as people care about liberty, the Constitution has a meaning to it. Now, how that meaning affects our daily lives changes with circumstances. There's a famous case a few years ago called Kylo versus the United States, not to be confused with the Kelo case. The Kylo case was about using infrared cameras to detect people who were growing marijuana in their homes under, in hydroponics, and they had the sunlights and everything. And the question was whether cops can use infrared detectors without getting a warrant. Well, obviously, when the Fourth Amendment was written, nobody had infrared detectors. So what the court was required to do in that case was apply this principle, no unreasonable searches, and you need a warrant, and so forth, to current technology and current circumstances. And in that sense, it's a living document. But the sense that phrase is usually used by progressives, what they really mean is the Constitution is a dying document. What they really mean is the provisions of the Constitution should be ignored, like the Public Use Clause of the Fifth Amendment, like the Due Process Clause of the 14th Amendment, right? Or that should be so radically rewritten that the constitutional limitations are rendered void, such as the current interpretation of the Commerce Clause. When you read the Constitution this progressive way, what you end up doing is having a Constitution with all sorts of dead spots in it that are no longer enforced. The best example in contemporary time is the Commerce Clause. Under the Commerce Clause, which allows Congress to regulate interstate commerce, Congress now claims authority to regulate things that are neither interstate nor commerce, including, most recently, the right to force us all to buy health insurance whether we want to or not, on the theory that buying or not buying health insurance has an effect through supply and demand on the price of health insurance in the national market. Well, absolutely everything has an effect through supply and demand on the economy. Our decision to be here tonight has an effect on the economy through supply and demand. Our decision to breathe has an effect through supply and demand on the economy somehow or another. If that's Congress's power, then why did the framers write the rest of the Constitution? Why didn't they just write a one-sentence Constitution? Congress can do anything that affects the economy. Right? That's obviously not what they meant. Article 1, Section 1 of the Constitution says all legislative powers herein granted are vested in Congress. Not all legislative power, but only those legislative powers herein granted. Right? And yet that clause gets erased from the Constitution if you follow the contemporary understanding of the Commerce Clause that was basically created in the 1930s by the New Deal Supreme Court.
In what ways, Tim, does government restrict the right or impinge upon the right of people to earn a living?
How long do you have? Let me take an example, a case that I'm working on right now just down the road in Missouri. I represent a guy named Michael Muni. He runs a moving company in St. Louis. If you want to run a moving company in Missouri, you first have to get permission from all of the existing moving companies. Now, surprise, surprise, the existing moving companies aren't really eager to have new competition. Right? What happens is when you apply for a license to run your business, the Department of Transportation notifies all the existing moving companies and gives them the chance to object. And when they object, you have to go in front of a board of bureaucrats and prove to them that there needs to be a new moving company. Now, how do you do that? We don't know because there are no guidelines in the law. There are no standards of evidence. There are no rules. It's just whatever the bureaucrats feel like. But aside from the legal question, how would you go about proving that there needs to be a new business? I first went to Starbucks in 1993. I was visiting Seattle, and a friend of mine took me there and was like, "You got to try this place. It's going to take the world by storm." I was like, "Yeah, right." If you had to prove in 1993 that the country needed a new coffee shop, that's ridiculous. There's plenty of coffee shops in America, right? But it turned out that people really did want a new chain of coffee shops. It's Starbucks. The only way to find out whether there needs to be a new business is to try it. Nevertheless, the law in Missouri is that you have to prove to a board of bureaucrats that there needs to be a new moving company. Now, this kind of law does not protect the general public, right? Law exists to protect the public against wrongful acts, to make sure I don't get ripped off or run over by the moving van or have my stuff stolen by the moving company or something like that, right? That kind of regulation, perfectly legitimate. That's what law exists to do. This law doesn't do that. In fact, the general public is not allowed to participate in the system. Only existing moving companies are allowed to object to their own competition. So here we have a law that exists only to protect established companies against fair competition from entrepreneurs like Michael Muni, who don't ask for a handout. They're not asking for some kind of a check or a preference from the government. They're asking to be left alone to earn an honest living for themselves and their families. And incidentally, in the kind of entry-level business that helps the poor and the underrepresented and members of minority groups and inner-city residents and immigrants the most. We were talking at dinner, we were talking about the taxi cab regulation. Taxi cab regulation in this country, in every major metropolitan area of this country, is done just like this. You have to first get permission from the existing taxi companies. Now, 100 years ago, you could have taken your Model T and painted on the side of it, taxi, and no matter if you were an immigrant just off the boat from the old world, you could have earned an honest living for yourself and your family, providing people with a service that they need for a price they're willing to pay. That's the American dream. But now you first have to go through agencies, get licenses. Often some of these licenses require multi-year educational requirements that cost tens of thousands of dollars. People cannot afford these restrictions. And these limiting restrictions, what they do is they bar from economic opportunity those who need it the most. The reason is established companies have the money and influence to get the government to do their bidding. They get exemptions, or they already have licenses, or whatever. It's not Allied Van Lines or Atlas Van Lines or something that's worried about the Missouri mover law. It's entrepreneurs who want to earn an honest living by driving a truck around and helping people move their furniture. That's just one of the many examples I talk about in the book of how government frequently violates our right to earn a living without unreasonable interference.
But what you're saying, if I understand you correctly, and you may get questions on this when we go to Q&A in a few minutes, you're basically saying that these restrictions affect not just wealthy people, but disadvantaged people who are trying to realize the American dream.
They have a disproportionately negative impact on those who are not wealthy. And the reason for this is a very simple principle called rent-seeking. Rent-seeking is the method by which, it's the most important thing you can know about government. Rent-seeking is the principle that says when government can redistribute wealth or opportunities from one group of people to another, that power is worth a lot of money. And so that power is going to fall into the hands not of the most deserving, but the most economically and politically well-connected, right? It's going to fall into the hands of those who know people, those who go to the city council and say, hey, why don't you give me this protection, and so forth and so on. So you can do a simple thought experiment. Suppose that I'm the government. Let's say there's 30 people in this room, and I'm the government, and I'm going to tax you all $1 each. So now I've got $30 in my hand, and I'm going to give that $30 to one of these three people over here. Now they're going to try and persuade me to do that for them. How much are they going to spend to convince me to give one of them the $30? It's simple gambling odds. You take your jackpot times your chance of winning. So it's $30 times your 1/3 chance of winning. Each one of them is going to spend $10 to persuade me to take me out to dinner or whatever, to persuade me to give them the money. Now how much are the rest of you going to spend to persuade me not to take the dollar from you? $1. You're not going to spend $5 to persuade me not to take $1 from you. So I, the government, think that there's that the general public wants my new fantastic wealth redistribution program, because I get all this lobbying over here. And you guys, just a bunch of grumbling Tea Party people. Who cares about you, right? So what we have is a ratchet effect where government constantly grows because there's so much investment on gaining the benefits, but there's no investment on resistance because it doesn't really cost you enough. You have other things to worry about. You have families to care for, you have jobs to hold down, and so forth. You can't afford to go down to the city council every night and say, please respect my rights today, and then the next day go to the city council, please respect my rights today, and then the next day, please respect my rights. How many of you have been to a city council meeting? Right? And you're the kind of people that come to events like this, right? So most people don't go to city council meetings. They can't afford it, right? It's not worth it to them. So they end up losing their opportunities, their wealth, their resources to the politically well-connected, who of course become even more politically well-connected as time goes on. This is why I tell my liberal friends who think that government should be in the business of wealth redistribution, what you're doing is playing into the hands of precisely the wealthy, well-connected, evil corporations that you most dislike. Wealthy, well-connected corporations love government. The biggest lie the American people have allowed themselves to believe is that big business likes free markets. Big business hates free markets. It has stopped at nothing to shut down free markets, to exploit government, to stop competition with them. Right? Target could make way more money if they outlawed Walmart. And they would love to do it. And there's no way that you can stop them from doing it except by saying they may not use government power. And that's why we have a Constitution of the United States. I said you people don't go to city council meetings to ask the government to protect your rights because you don't have time to do so. So instead what you do is you get together and you write out a charter and you say, government may not steal my money and give it away to somebody else. And now your problem is solved and you can go about your business, don't have to worry about it. That's the Constitution of the United States. And what courts have done since the 1930s, when they turned their backs on these rights, what courts have done is they've stood back and they said, we're not going to stand in there and protect your rights. We're going to let government redistribute this wealth and these resources. Long answer to your question.
No, very, very helpful. You mentioned a few minutes ago healthcare, so I'm curious about getting your assessment of how this last session of Congress has affected individuals' right to earn a living.
Well,
and as a subset of that, as somebody who studied the Constitution extensively, and I'm going to ask you to make just a prediction here, will the Supreme Court throw out health care?
The first question is actually more difficult to answer. How the Obama administration's health care legislation affects the right to earn a living, there's certainly no question that it is the biggest burden ever put on small business in the history of this country.
And why is that, Tim?
Because it requires for nothing else, it requires so many reporting requirements for small businesses that even when they deal with independent contractors, they're required to fill out all this paperwork and so on. It's easy to think, yeah, paperwork, whatever. Paperwork is a huge cost on government. It's a huge cost on time and resources. And so that alone is a huge problem. But it's not so much just economic. I mean, it's not entrepreneurs alone who are affected by this law. The fact that the government is claiming the authority to force us all to participate in commerce, not just regulating commerce, but forcing us to engage in commerce, is an unprecedented expansion of federal authority that flies in the face of the entire constitutional tradition in this country. The Constitution of the United States creates a government of limited, enumerated powers. What that means is, if it's not written in the Constitution, Congress cannot do it. Right? But what has happened is, the Commerce Clause has been interpreted in such a way as to say anything that has any effect on the interstate market can be regulated, which of course, as I said, is absolutely everything. If that's what the founders meant, then they wouldn't have written the rest of the Constitution. So the problem with the Obama administration's healthcare legislation as a constitutional matter is that it would, if it is upheld, it would set the precedent for allowing the federal government to regulate absolutely every activity of behavior. There is no reason why the federal government could not force you all to buy a car from government-owned General Motors in order to improve the economy, or force you to drink a tall glass of milk before bed every night because it makes you stronger and therefore makes you healthier and therefore makes you better able to produce the wealth that the government's going to redistribute and so forth. Right? In her confirmation hearings, Justice Elena Kagan was asked, under your understanding, wouldn't Congress be allowed to force us all to eat vegetables every day? And she laughed and said she would think that such a law would be silly, but she didn't say no. Right? Because she can't say no. She does think that that's what the Commerce Clause allows. Now, what will the Supreme Court do? A little dangerous for me to get into this prediction business, in part because I represent Matt Sissel, an Iowa resident, in a lawsuit challenging the constitutionality of this law. There are right now 19 pending federal lawsuits challenging the constitutionality of the healthcare legislation. In those cases, there have been 6 decisions rendered. Those were all on the government's attempts to dismiss the case. Of those motions to dismiss, 4 were denied. So 4 cases are going forward, and 2 cases have now been dismissed. And we are waiting on 2 decisions on the actual merits of the case, and that is the Virginia case and the Florida case. The Virginia case has been argued, and we will probably have a decision from a trial court on the constitutionality of this law by the end of the year. The Florida case will be argued December 16th, I believe, so you'll see that on the news very soon. And then as far as what the Supreme Court will ultimately do in these cases, well, a lot of attention, of course, is focused on Justice Kennedy. And Justice Kennedy decided a case earlier this year, I think, or late last year, called Comstock. And Comstock's a very interesting case. Comstock is about the necessary and proper clause. But what he says is applicable here, too. What he said in that case is that a federal law will not be necessary and proper if it intrudes on traditional state functions, or radically alters the federalist system, or otherwise changes the nature of federal power under the Constitution to a great degree. So that decision, it was just a separate opinion, but that decision gives a lot of hope to those of us who think that this law is unconstitutional, that Justice Kennedy might be on our side on that. But, you know, the other side, the proponents of the legislation, they have a lot of precedent on their side. The Supreme Court undeniably has expanded the Commerce Clause power far beyond anything that the founders had in mind, far beyond. And so that Congress can, there was the Raich case, the marijuana case, where Congress said that the Supreme Court said Congress can regulate your growing marijuana in your own yard for your own personal consumption, never crosses state lines, no commercial activity involved. Nevertheless, it's interstate commerce and Congress can regulate it. Those kinds of precedents really, that makes a steep hill to climb. And I think it really is time to amend the Constitution to clarify what authority Congress has under the Commerce Clause.
Mm-hmm. Okay. We're going to open it up to Q&A after one more question I have, so be thinking about questions. And if you do have questions, raise your hand, and one of our students will bring a cordless mic by for you. Tim, what does the future hold in this area?
I'm reminded of a speech my friend Tom Palmer gave a speech once right before the presidential election, and somebody said, who's going to win the presidential election? And he immediately said, the government. So it's impossible to say what the future holds, but I actually am optimistic for a couple reasons. The first reason is I run Pacific Legal Foundation's law clerk program. So I review the resumes of the law students who want to work for us for the summer. And it's amazing to me how many law students say to me, I went to law school because I was so mad about the Kelo decision. There really is a backlash, and not just a backlash among average Americans, but a backlash among the rising intellectuals, the rising generation of lawyers who will charter the future of this country. The progressive movement took at least 50 years between the publication of Edward Bellamy's socialist utopian novel Looking Backward and the 1934 decision in Nebbia. And that was a long period of debate and argument in the universities, in the law schools, among the philosophers, among the activists, and so forth. We have a steeper hill to climb, those of us who believe in limited government and individual rights. So it's going to be a long process, but I'm very hopeful for that reason. And the second reason is things like the Tea Party movement. Now, there's a lot of stuff about the Tea Party movement I really don't like, but at heart, what I think the Tea Party movement is about is people awakening to their constitutional history, the Constitution's principles, taking it very seriously and wanting to stand up and say, this is my Constitution too. And it is. I mean, the Constitution was written in language that the common person can understand. It takes many years of sophisticated legal education to misread the Constitution the way the Supreme Court does. All of us can understand the plain language of the Constitution, and an increasing number of Americans are trying to do so. I give speeches, and it's amazing how many people there will say, well, what about the Supreme Court's decision in Wickard versus Filburn? Now, 10 years ago, 5 years ago, I don't think anybody in the audience would have heard of that case, but everybody knows these things now. And so that makes me very hopeful, at the very least, that we're paying attention to these issues. Because as I said before, the Constitution is not a machine that will go of itself. It will not go if we don't believe in it. Alexis de Tocqueville said in Democracy in America that the great weakness of America is that the majority really does have absolute power. But the saving grace of America is that social mores and social beliefs are such that there are some things the majority doesn't even imagine. The problem is that in recent decades, we've started to imagine it. We've started to say, yes, government can steal Suzette Kilo's house and give it to a private developer for her own private use. We've started to say, yes, the government can tell us all to participate in the market whether we want to or not, all these sorts of things. And I think we're seeing a reaction against that, and not just a reaction against something, but a promotion of something positive, and that is stronger protections for the individual liberties that the Constitution was designed to defend for ourselves and our posterity.
Okay, very good. Let's open up to your questions. Please raise your hand, wait for a mic. We'll get this one right here first. I know that there are probably a number of you who agree with Tim. There's probably a number who disagree. Well, if you disagree, pipe in and ask a question right here.
Hi. You told us what you like about the Tea Party. What is it that you don't like about it?
That's the first time I've ever been asked what I don't like about the Tea Party. Two things immediately come to mind. I think that the religious conservative elements of the Tea Party have proposed some things that are very dangerous to the separation of powers, or separation of church and state, rather, in this country. Well, there are people who argue that schools should be used, that government-run schools should be used as a location for preaching religion to students. And as the thing that scares me a lot more than that is the popularity of arguments in favor of nullification or even of secession, which I have heard the governor of Texas speak positively about the idea of secession. Congressman Ron Paul has spoken positively about the idea of secession. The legislature of Texas, there was a bill introduced just this week that's attempting to nullify the Obama administration's health care mandate and declare that it is not valid law in the state of Texas. Nullification is utterly and totally unconstitutional. Secession, of course, it should go without saying, is utterly and totally unconstitutional and was from the beginning. Unfortunately, I see a lot of pseudo-libertarians associated with groups like the Mises Institute or Lou Rockwell, who are making sophistical, pseudo-intellectual arguments in favor of scandalously unconstitutional and unprincipled doctrines that not only are totally contrary to the Constitution, but would allow states dramatic more power over our individual rights. Ron Paul, for example, argued that the Lawrence versus Texas case was wrongly decided because states should be free to tell us whom we are allowed to go to bed with. And he calls himself a libertarian. I think that is deeply shameful. And so those doctrines, I see the rising popularity of those doctrines. That scares me a lot. What we need is not to come up with silly, outdated, dangerous arguments about that would allow states to tyrannize over us and so forth. What we need is a restoration of our original constitutional principles.
So you're saying that these are things that are developing in the Tea Party, in Ron Paul, in the governor of Texas, and all that are representative of these ideas that come from the Tea Party?
That's right, yes. And I have seen people even argue that the 14th Amendment should be repealed. The 14th Amendment is one of the greatest achievements in the history of human liberty. And the idea that people would actually openly advocate the repeal of the 14th Amendment it should be shunned.
Okay, we need to move on and get another question. Other questions right here. We have a lot of students out there, so guys, I want to hear some questions from you too.
So how do you reconcile, or maybe what recourse would states have under their 10th Amendment rights if nullification isn't a valid recourse?
Yeah, so this has been a problem because the 10th Amendment, of course, says, what the 10th Amendment says is if Congress doesn't have the power, the states have that power. And what we've had is the courts have been increasingly expanding Congress's power. Well, then it follows that the states don't have that power, and so the courts then just ignore the 10th Amendment. What the 10th Amendment does is it's like a stop sign or a whistle that says, hey, hold on a second, you're misreading the Constitution here, right? It doesn't have the kind of force that says states may do this, 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 and this. What it says is, read this Constitution in a way that favors state power over federal power, and we've been ignoring that. Another problem, a more technical problem, is that there's still a question over whether you can sue the government, the federal government, for exceeding its powers under the 10th Amendment. And there's actually a case that's going up to the U.S. Supreme Court on the question of whether you and I, whether individuals, have standing to bring that argument. I think we certainly ought to have standing to bring that argument. But what actual legal recourse we have, unfortunately, other parts of the Constitution have been tinkered with over time to reduce state autonomy. I think the direct election of senators, for example, has reduced the ability of states to resist federal encroachment. Now, maybe people really do feel that the federal government should take more power and that the states should have less power. And if people really think that, as long as what they're doing is just, I don't care whether something is done one way or the other. There's political arguments why local power is better than distant power, and that's fine. But if the people of America really do want to amend the Constitution to give the federal government more power, that's their decision. There's nothing holy about states. And in fact, in Federalist 45, Madison says just this. He says, the idea that if the public happiness is irreconcilable with states' rights, then states' rights must yield. So that's my view. But what recourse states have is, I think that they can file lawsuits, certainly they can pass resolutions that protest expansions of federal power, but they have been severely hampered in their ability to resist federal increase.
Okay, let's go to right here.
So if the Supreme Court actually rules that the states are correct and that the federal government has overstepped its boundaries when it comes to the Commerce Clause and this Health Care Reform Act, would you see possibly a change or a re-examination of those previous cases?
They certainly would have to re-examine and reconsider them in order to make such a ruling. I think what you might find is the court's going to look for where can we draw the clear line and get rid of this problem as easily as possible. Right? That's what judges do. Judges' job is largely to say, how little do I have to do? So to some degree, they're going to say, how little do we have to really tinker with the system? And what they'll probably do if they rule in the direction that we certainly hope is they'll say, well, government can regulate activity. The word regulate means I'm engaged in an activity, so you can regulate it. It doesn't mean government can force me to undertake that activity. When the Constitution does give Congress the power to make you do something, it uses different words. Right? The Congress has power to raise an army, and the Supreme Court has said that includes the power to draft you into the army. right? Because it can raise an army, and the word raise is different than the word regulate. The word regulate means you're already engaged in that activity, right? So that's a clear line to draw. They can say, well, you can attach the requirement to purchase health insurance to an activity, but you can't force people just in itself to purchase health insurance. That might be the easiest way for them to do it.
Do you see challenges from the court, challenges to the Supreme Court on those previous decisions?
Do I see challenges to those previous cases? Oh, yes. Of the 19 cases, I believe all of them make this Commerce Clause argument. The Florida case has been thoroughly briefed very skillfully on a lot of these questions. The Virginia case, as I said, has been fully briefed and argued, and we're waiting for a decision. And actually, one of the really good, well-framed cases is the Missouri case. The Missouri lawsuit against the law has been kind of in a holding pattern in the federal court over there in Missouri. I'm not sure why, but it hasn't gone forward yet. That makes some very interesting and very convincing arguments against the constitutionality of this law on other grounds that I haven't mentioned.
Okay. Other questions? Do we have some students who have questions? Okay, let's go right here.
The title of the talk is The Right to Earn a Living. How do you feel about licensing laws, medical licensing laws and others?
Thank you for that question. I think licensing laws, first, I think licensing laws tend to be just ineffective. I don't think they're very good at protecting the general public. The general public doesn't look for a government license usually to determine whether whether a product or a service has quality. When I buy a product or a service, I look to see if there are any reviews on Amazon.com. I don't look to see whether the guy has a license from the county of Los Angeles, So I don't think that licensing is a very effective measure, and there are some economists who have done some very sophisticated analysis that have found that for the most part, licensing just doesn't really do a very good job of protecting the consumer. But beyond that, I think it is very dangerous. Now, the first U.S. Supreme Court decision on the constitutionality of occupational licensing was a case called Dent versus West Virginia in the 1880s. And that case involved licensing doctors. And my hero, my favorite U.S. Supreme Court Justice, Stephen Field, the first Californian on the U.S. Supreme Court and the only U.S. Supreme Court justice ever arrested for murder. That's a story for another day. Justice Field wrote the opinion, and Justice Field is my hero because he believed very strongly in the right to earn an honest living without government interference. Nevertheless, he upheld the constitutionality of licensing for doctors, and he said the reason why this is an okay idea is because government can protect you against fraud or against people who are going to hurt you or rip you off or something. And it can do so by letting you sue the guy afterwards, but with doctors you can't do that because you're dead. So licensing helps to ensure quality to some degree beforehand. But, he said, licensing requirements must be related to the occupation, and the requirements must be reasonably attainable to everybody. Because if the licensing requirements are so difficult or expensive or complicated, then they will just be used to give preferences to established businesses against fair competition. Now, I'll tell you about a case I worked on a couple years ago. My client, a guy named Alan Merrifield, he ran a pest control business. He installed spikes on buildings to keep pigeons from landing on them. You've seen these in the cities, right? So that's what he did. He doesn't use pesticides. He doesn't believe in pesticides. Just install spikes or nets or things like that. Well, in California, if you want to do that, you have to first have a Branch 2 structural pest control operator's license. And to get a license requires 2 years of training learning how to handle and use and store pesticides. And then you have to take a 200-question multiple-choice exam. Now, I'm not allowed to tell you what's on that exam. The court has ordered me not to. But I can tell you what's not on that exam. There's not a single question about pigeons, and there's not a single question about spikes. And it gets better, because the law only applies if you're dealing with pigeons. If you put the same spikes on the same building to keep a seagull away, you don't need any license at all. Now, I had the state's expert witness in there on a deposition, and this guy happened to have written this law. And I said to him, now this law requires 2 years of training to put spikes on a building to keep pigeons away. He said, yeah, that's right. I said, but no training at all to put the same spikes on the same building to keep seagulls away. He said, yeah, that's right. I said, would you call this irrational? He said, yes, I would. And the government's lawyer says, can we take a break? So we come back from the break, and he says, I'd like to clarify what I said about irrational. I'm thinking, yeah, I bet you would, right? He says, you see, originally the license is required for every pest control job, but some people were saying, well, if we're not using pesticides, we're not a danger to the public, so we shouldn't need licenses. But those of us who had licenses already, we didn't want to face fair competition from new entrepreneurs. So we went to the legislature and we said, why don't you divide up this market and give us the most common pests, pigeons, rats, and mice, and they can deal with all the other pests. And I'm thinking, please tell me more, right? I go in front of the district court judge. I said, Your Honor, it is an undisputed fact in this case that this law is irrational. It is undisputed that this law was designed not to protect the public, but solely to protect an established industry against fair competition from others. And we lost. We lost because the law is so tilted against businesses under the rational basis test. Now, the happy ending of the story is we won on appeal. The Ninth Circuit Court of Appeals reversed that decision and said states are not allowed to use their licensing laws simply to protect established businesses against fair competition from others. So that's what the Economic Liberty Project exists to do at Pacific Legal Foundation, is to defend entrepreneurs who, like I said, they're not asking for special favors. They're asking for the opportunity to put their skills to work, providing for themselves, and to pursue happiness.
Do you have any other questions tonight?
Yes.
Not a single student has asked a question yet. It's okay.
I'm just curious.
We need to wait for a microphone, if you would. We need a mic up here.
Surely
So we can
somebody
get you
wants
on
to
audio.
know. Surely somebody wants to know why Stephen Field was arrested for murder.
Is the income tax legal under the Constitution?
Is the income tax constitutional?
Yes, and then following that up is, what do you think about the fair tax thing, the HR 25, I think it is. It's before the Congress, right?
I have to admit I'm not familiar with the fair tax proposal, but the income tax is constitutional. The Constitution was specifically amended to allow for it. Now there's a fun twist on that. The government is now arguing in the healthcare cases. The government is saying, oh, did we say Commerce Clause? We meant the taxing clause. The individual mandate is constitutional under the taxing clause. Now, I always tell people, maybe it was passed under the taxing clause. All we know is Congress didn't read the bill before they passed it, so who knows, right? But if it is passed under the taxing power, it's still unconstitutional, because the Constitution says direct taxes are unconstitutional, with the sole exception of income taxes, because there was an amendment. And since this is not an income tax and it is a direct tax, it would still be unconstitutional. However, the government has still not persuaded a single court that it's a tax, so I don't think they'll push that argument very hard.
Any other questions tonight? Did you see a hand? I didn't. Oh, okay, there you go.
Thanks. I wonder if you could speak a little bit more to the first couple of questions dealing with some of the things you mentioned as distasteful about what particular states are intending to do as sort of pushback now, and also various amendments delineating state powers. Are we to understand that the founders did not mean to give so much power to the states after all, enough power to be able to do various distasteful things you mentioned in the first answer to the first question, or that what the founders intended was to give the states that power, but that is inappropriate and has since been covered over with amendments since then?
Sure. That's a very complicated question, so I can only give a brief sketch of an answer here, and that would be this. The reason why nullification and secession are unconstitutional is because the Constitution differs dramatically from the Articles of Confederation that preceded it. The Articles of Confederation that was a treaty among states that were basically sovereign entities. It was kind of like the United Nations. It did not create a sovereign federal government, or maybe it did, but there was a lot of confusion over whether it did. So what the Constitution did to change that was it separated the sovereignty of the people of the United States into two tracks, and it said what we have is states are sovereign within their sphere, and the federal government is sovereign within its sphere, and the federal government derives its power not from the states the way that the Articles did, but directly from the people of the United States. That's what it says in the preamble. And when you read the debate, not the Philadelphia Convention debate, but the ratification debates in Virginia, Patrick Henry gets up. He's opposed to the Constitution. He gets up. He says the basic reason he's against it is because of this line, "We the people of the United States." He says, why, this would take power away from the states. This creates a sovereign federal government that is independent of the states. And Madison gets up and says, yep, sure enough, that's right. And it was well understood at the time of the ratification that that's exactly what was going on. So, including the opponents, they all knew it. So what happened was the federal government derives its power directly from us as federal citizens. The states derive their power from us as state citizens. Now, that was 1788. By the time the Civil War had come along, there was a real big problem. And that big problem was the word citizen was never defined in the Constitution of the United States. Now, that's really remarkable when you think about it, right? And this was a serious problem for a number of reasons. One of the big reasons was the status of black people who were not slaves. Were they citizens? In Massachusetts, they were. In South Carolina, of course, they were not. In the 1820s, South Carolina passed a law, the Negro Seamen's Act it was called, that said that any black sailor on a ship that landed in South Carolina had to be jailed until his ship left port at the captain's expense. And if the captain didn't pay for his lodging, he would be sold into permanent slavery. Now, this was, of course, unconstitutional under Article 4 of the Constitution that guarantees every citizen the privileges or immunities of citizenship wherever they travel. Nevertheless, even though the Supreme Court or a Supreme Court justice found it unconstitutional, it remained on the books for another 25 years. Right? So there was a lot of problems over this. And when the Civil War was over, what the radical Republicans wanted to do with the 14th Amendment was to make permanent something they thought had always been constitutional law. They wanted to make it unambiguous. It wasn't they were trying to change the Constitution. They were trying to say, look, from now on, what we thought was constitutional is the Constitution. And they did that in the 14th Amendment. The first principle was, we are Americans first and citizens of states only secondarily. So the first time ever the Constitution defines citizenship, it says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So that not only does the federal government decide who is citizens, but it even decides who is the citizen of a state, which South Carolina would never have stood for in 1830, let me tell you. Right? So what they said was, this principle that we are a nation first, that principle was always the law, and it certainly will be law from now on. And that's why states can't secede from the Union, even before the 14th Amendment. States can't secede from the Union because they aren't part of the Union in that sense. They aren't parties to the agreement. The people of the United States are parties to the agreement, not the states. So it's not like the United States saying we don't want to be part of the United Nations anymore or something like that. I have as much of a right to be part of the federal people as any person in any other state does. And I have the right under the Constitution to travel from state to state. The Constitution guarantees a republican form of government to every state. These provisions would not be operative if secession or nullification were constitutional. So the whole point of the new Constitution in 1788 was to take certain sovereign authority away from the states, and that is just the authority that secession or nullification rest upon. This is a very complicated subject, so what I would urge any of you who are interested in this stuff to do is there's two books that I would recommend. Akil Amar wrote a book a few years ago called America's Constitution, a Biography, the best book on the Constitution since the Federalist Papers. I say that being a libertarian, he's a liberal, we disagree on a lot, fantastic book. Another book called Lincoln's Constitution by Professor Farber, I believe. And that very briefly, both of those books will briefly explain why it wasn't just that the Union won the war, it was that the Union was right all along. And it's really tragic to see how few people in the academy and how few intellectuals are standing up and explaining why that is the case. And to see the rising popularity of these doctrines from the Old South is really chilling. I see some of my supposedly libertarian friends saying John C. Calhoun was a great hero of liberty, the man who invented the positive good school of slavery, the man who said that the Declaration of Independence had not a word of truth in it. He said, all men were not created, only two were ever created, and one was created subordinate to the other, end quote. Right? To see the doctrines from that period being reiterated today, as I have in some of these meetings, is very scary. On the other hand, I am convinced that it's just a matter of people need to learn more about the Constitution, and when they learn about these principles, when they read the Federalist Papers, and they read Akil Amar's book, when they read Lincoln's July 4th, 1861 speech, I think they will return to the true doctrines, the true faith of the Constitution and the Declaration of Independence.
Any other questions tonight? Andrew?
Is there room for compassion in lawmaking?
Is there room for compassion in lawmaking? Of course.
Do you want to ask a follow-up, Andrew?
However, there is no room for using one's compassion as an excuse to steal money from people who have earned it to give it to people who do not. Just like I have no right to steal your house and give it to somebody that I think is more deserving. My compassion is limited by your rights. And I have every right to tell you, you should donate more this year to some charity or something. I have the right, of course, to set up a charity and run a charity of my own to provide for people who I think need care. I donate quite a lot of money to charity. I work for a nonprofit. But you don't have the right to violate somebody's rights and then say, well, I did it for the best of motives. I'm sure that I could do a lot of good with your money. But it's your money, and I have no right to do that.
Other questions? Question right here. Great.
How do you feel about the TSA in the airports?
How
they
do I
let people
feel
down?
about the TSA? Well, I think it's kind of silly to a lot of what they do is obviously just, I think it's ineffective. It's what the term that people are using now is security theater. I think that's a great term for it. I'm convinced that what it exists to do is to make us feel like we're protected in some way when we're not. Everybody in this room who has flown in the past 10 years has at one point or another gotten on a plane with liquid in their bag or something like that, right? I think that kind of thing is very silly. As far as how intrusive it is on our liberties, certainly I think that that government does things all the time that intrude on our liberties, but I'll tell you what, there's a lot of people out there who are really outraged about the TSA. And what my advice to them is to look at the other things that are going on in this country that deserve much more of your energy and outrage. A great example of this would be the unconstitutional, immoral, unwinnable war on drugs that violates the rights of every person in this country every single day, and especially the poor members of minority groups who need protection and don't get it. We have a system in this country that takes especially poor black boys, puts them in schools where they learn nothing, graduates them with fake degrees they can't even read. We use minimum wage laws to make it harder and harder for them to find jobs. And when they finally find the only employment left to them in selling drugs, we send police officers to kill them. Now, if you want to get outraged about something, get outraged about that.
What can we expect in the future when we get rid of social welfare programs that may be indeed helping these poor black children?
I don't think we will get rid of these social welfare programs.
But if you
But if we did, I think what you would see is a flourishing, even more than we already have, of private charity in this country. This country is the most charitable country in the world. It is the amount of money and energy that go into charitable programs in this country is astonishing, and I think you would just see an escalation in that. A lot of the time, I think one of the saddest things, I mentioned the lies that Americans have come to believe. One of the biggest lies Americans have come to believe is the Dickensian picture of the evil days of laissez-faire and the working man being trampled on in the 19th century and everything. No doubt it was miserable to live in a time before refrigeration and vaccinations, but the fact is that standards of living were rising dramatically, and that was also the time when you saw the hugest outpouring of charities. If you look at, for example, just look at when the great charities in this country were founded. They were all founded during the so-called age of heartless, non-compassionate, laissez-faire capitalism. Right? Even the ASPCA was founded in the 19th century. So I have no doubt that the poor in this country would not only survive, would do better under a situation where government was not in charge of making sure that they get their health care and their food, but where private people who actually care about this stuff devote their time and energies to it as entrepreneurialism has allowed them to do.
Okay, we're going to take one final question.
Consistent with your views, you mentioned just a minute ago the poor education system we have in the United States. What, ideally, would you like to see in our education system?
What would I like to see in our education system? Short-term...
And how would it be funded?
Okay, short-term versus long-term. Long-term, I believe in the total separation of state and education for a number of reasons. The first is government is not equipped to provide education to people. It's just bad at the job. And the second is it really has no business doing that. That said, and the third reason is because the opportunities for abusing that power are so dangerous and so present. I mentioned earlier people trying to use government-provided schoolrooms to teach religion to children. That is obvious. That's a constant problem in this country, and it's precisely because government runs a veritable monopoly on education. But the same is true of any other thing. I mean, economic doctrines or literary theories or what have you. I mean, government has no incentive to teach kids to be skeptical of government. So why should a free society that rests fundamentally on skepticism toward government give the minds of its children to the government? It's a shocking proposal, or it should be, if we hadn't all been graduates of public schools, so that we aren't shocked by that sort of thing. I say this as a graduate of public schools myself. I also think that obviously the abuse that teachers' unions and things have engaged in should also make us very skeptical. Short term, what do I think would be a much more realistic goal? A lot of my libertarian friends who say separate government and schooling, I say, well, government has been involved in schooling in this country before this was a country. I mean, the Puritans set up government-funded schools, so I'm under no illusions as regard that. I think school choice programs, and the more choice, the better. If any of you have not seen it yet, I urge you to go see the movie Waiting for Superman, which I recently saw in Phoenix, and I'll tell you, another thing, you want to get mad about something, you go see that movie, and you will walk out of that theater steaming mad about what we do as far as educational opportunity is concerned in this country. It's shameful that we have allowed the teacher union monopolies to bar the competitive possibilities that are open to us obviously in the voucher programs, but even in things like charter schools. So the more choice, the better. The more parental choice, the better. The more parental involvement, the better. And let these kids go. Let them have the opportunities that they need. And I don't say that to disparage teachers. This is the red herring, the straw man that's always thrown up. Oh, well, you're just razzing on teachers, and teachers are wonderful people. I'm sure some teachers are wonderful people, and I'm sure some teachers are lousy people. That doesn't change the fact that government does not reward the good and punish the bad the way some people naively seem to think that it does. And it doesn't have any more expertise at running schools than it has at running a post office, or at running the Veterans Administration hospitals, or at running the Department of Motor Vehicles. It's all a matter of incentives, right? So what we have now is an incentive structure where failing schools get more money, So I think what we need is, as I mentioned before, I said economic freedom is the freedom of economic choice. What we need is more freedom to decide for ourselves how we're going to run our lives without the government telling us how to run our lives. If it's true in the realm of religion, it should also be true in the realm of education, and it should also be true in the realm of the freedom to open a business and run that business as you see fit.
Tim, thank you very much.
Thank you very much.
We really appreciate it.